we have a glitterati of the Chancery Bar.
And me and Tim.
To share their learning, thoughts, experiences, concerns on a diversity of topics in this field, from missing persons to missing capacity. Now, there's going to be at least two differences to this conference to many of the conferences out there. The first is that it seems to me that it's a bit like speed dating. But it's going to be speed succession, or perhaps it'll be succession on speed. I haven't quite worked out which, and perhaps you should be the judges of that. So the presentations that you're going to receive are going to be short, snappy, and memorable. The second difference is that many of the presentations, you're going to be hearing from the horse's mouth what really happened in a case of moment. And I always find it much more instructive, actually, to listen to somebody who's been involved in a case, explain what it was all about and what the ins and outs of it were, than simply reading the judgment. So, meanwhile, Chambers continues to go from strength to strength, punching well above its weight, and members dealing with cases from sort of intergalactic litigation on an industrial scale through to cases which appear on page 1 of the Daily Mail, I think, Edward Cumming and Alex
Page 91, I think.
Page 91. They are acting for the children of Terry Jones of Monty Python fame, who, it seems, are older than the second wife, in whose favour, or a will more favourable to the second wife was executed, or so it is said, and there's a challenge about that. So from that to those who actually make new law, and there I refer to Tim Sherwin's case, and he argued in Boothman and Horsford that beneficiaries of Estate A are entitled to an account of Estate B, they having an interest in Estate B through Estate A. So that's an interesting decision. So you can see from that there's a wide variety of matters in which we get involved. Before I introduce the first speed session, I hope you all receive our monthly private client updates. If not, please do speak to one of us and we will have you added to the list of recipients. And there's also a repository of them on our website. So if you look at news and then legal updates, you'll find a wealth of instructive material there, which is a really useful resource. So, our afternoon today is kicked off by Edward Cumming QC and Timothy Sherwin. Edward is described in the directories as a superstar in the making. Well, they've obviously got that wrong because he is a fully formed star. And Tim was recognised in Chambers' High Net Worth as a star junior under 10 years cool when he was only 6 years cool. So, here are two stars to take you into a whirlwind.
It was Lord Acton who said in, if I master the slides, that would be a good start. It was Lord Acton who said in a letter to Bishop Crichton a few years ago now, power tends to corrupt, and absolute power corrupts absolutely. Great men are almost always bad men, even when they exercise influence and not authority. Still more when you superadd the tendency or the certainty of corruption by authority. There is no worse heresy than that the office sanctifies the holder of it. Well, so many of the disputes that you no doubt encounter, and that we certainly encounter, are concerned with power and influence, either power and influence that can be exercised in the future, or resentments even about power and influence that's been exercised in the past. And that's perhaps never more so than in the context of the sorts of issues that Tim and I want to talk about in our first session today. And they're issues that members generally at 24 Old Buildings have been seeing more and more in recent years. And they concern the situation where there's a battle for control of a trust structure or a business empire or a combination of the two. And one of the key components of that battle is where a significant figure has begun to lose capacity or is said to have begun to lose capacity or to have lost capacity by one or other of the jostling power groups that exist in or behind the structure. So on the trust side of things, you may have trustees or other power holders who are accustomed to acting in accordance with the instructions of the client, namely the settlor, who may or may not be a beneficiary and therefore may or may not have particularly pertinently relevant views, and it may be said that the settlor has begun to lose capacity and they may only get information through a family office. The trustees may never actually have had much direct contact with the settlor at all. Alternatively, you could have a settlor or other significant figure in the structure who has particularly important powers, powers of veto, powers to hire and fire trustees, and it may be said that they're losing capacity, or they may be reluctant to exercise a power to fire the trustee, and it may be said, well, come on, we need to get somebody new in now. Dad, mum has clearly begun to lose it. We need to get a new kid on the block, namely me. And on the company side of things, you may often have the matriarch or patriarch who is either the sole director of a key corporate vehicle, or they may be the swing vote on a board that's otherwise very carefully balanced. There may be big decisions that have to be made, and it may be said that the patriarch, matriarch has lost capacity or begun to, and therefore can't exercise that swing vote or sole vote. And so we're seeing all of these issues more and more, and I think that's for a variety of reasons, partly because people are remaining active until a greater age than ever before, and so they're more likely perhaps to be involved in many of these issues. Also, the key individuals in lots of the structures that were set up probably in the 80s and 90s onwards are now reaching what I think is euphemistically called a certain age, where these sorts of issues are likely to arise. Structures, of course, are becoming increasingly complex themselves, and that's likely to lead to more problems in this area. And communication is so much quicker and easier and less deliberate than it's ever been before, which leads to much more confusion in this sort of area. And the reason Tim and I are particularly interested in this is because although we're seeing these issues more and more, the actual legal, technical, tactical considerations around how you tackle a lot of this, as distinct from the question of how you actually medically or medico-legally assess capacity, isn't something that seems to be talked about very much. And we think it's quite interesting in this scope to talk about it much more. So we're hoping to address that a little bit today. And we're hoping to do it on the following basis. First of all, to outline a little bit about the interaction between the Court of Protection, trusts and companies. Then to think about the tactics that might be pursued in different courts and different approaches that can be taken. Then to look at some issues that arise in the context of documents that you might obtain through Court of Protection proceedings, but might be particularly pertinent or useful in other avenues, and then finally to take a step back and look at the big picture. So, without further ado, Tim, can you talk us through this short example, just to try and give a bit of colour to what we're going to be talking about, that's based on a couple of cases that we've both been involved in?
Thanks, Ed. Yeah, so what I've tried to do here is draw you a picture of something that is realistic, albeit perhaps a little bit complicated. So, P is on the right. We're going to have to imagine, for the sake of argument, that P is... Sorry. We're going to have to imagine, for the sake of argument, that P is in what I think, in an insolvency context, would be called the penumbra of incapacity. So there's some doubt over whether or not P has lost capacity. That's important because, obviously, if we're talking about the Court of Protection, we need at least a pretty good question before the Court of Protection's jurisdiction is engaged. But, as in so many of these cases, and we know from all of us who are involved in capacity litigation know, even in cases where there is an established dementia, the downward curve is often spiky. There are good days, there are bad days. It can be very difficult to know on any given day, let alone in respect of any given decision, whether or not P does or does not lack capacity. Now, P sits in the centre of the spider's web. He is a trustee of a charitable trust which owns a PTC, a private trust company. And so he has important powers as trustee right at the top of the structure, and that's the top line on our diagram. He also is an independent power holder in respect of the trust. He has, let's say he's a protector. He's a protector with a power of appointment and hire and fire powers in respect to the trustee. So key powers, the exercise of which will very significantly affect the entitlement of beneficiaries under the trust, and also people in the around the trust, so the trustee itself, family members who may or may not be beneficiaries under the trust, etc. Then we have a trading company, an operating company held under the trust, of which he is a director. And one of the things I think is really interesting about this is you sometimes see the matriarch, patriarch appointed as an investment advisor, sometimes as director, sometimes even as an entrenched director, whereby their role in the company is protected pursuant to the Articles of Association. But all of those roles become really difficult when you have capacity issues, because it's never black and white when P does or does not have capacity. And we've also added a UK property in there, because I think one of the really interesting questions that very frequently arises is when you've got family members who are indirectly dependent on P. So you've got family members, for example, who live in the house, who want to live in the house, and are dependent on P's largesse to a greater or lesser extent in exercising his powers to tell the trustees what to do or not to do. So that's the structure that we want to start by thinking about. And I think what we're going to try and do during the course of the next sort of 20 minutes or so is try and work through some of the options about where problems are likely to arise, where attacks might well arise from various people in the structure, and how the interaction between the different courts may play out in reality, and particularly how we're starting to see people using those different courts in different ways to try and solve problems, but not always in a totally joined up way. You know, there's a sense that people can sometimes leap to go and try and, you know, shout undue influence, go to the business and property courts, or leap to shout lack of capacity, go to the Court of Protection, when actually that can sometimes be quite difficult in the context of a wider battle for control. So, Ed, I don't know if you had any observations on this structure to start with, or we're going to jump straight into tactics.
I had no observations on the structure, not least because I have one eye on the time. The first port of call often is going to be, when you're thinking about potential lack of capacity, the Court of Protection, for obvious reasons. It is, however, important to bear in mind what assistance it can give and what assistance it can't give. Tim's already alluded to the threshold that you have to clear in order to engage the jurisdiction of the Court of Protection, and the leading case on that's Re F, in which it said there must be sufficient evidence to justify a reasonable belief, so not just a reasonable belief, but sufficient evidence to justify a reasonable belief, that P may lack capacity in the relevant regard in respect of which you're seeking to engage the Court of Protection's jurisdiction. If you clear that hurdle, you can seek relief under Section 15 of the Mental Capacity Act, of course. Now, the first two limbs of the relief you can get there are declarations as to current capacity to carry out certain acts, or past capacity to have carried out certain acts. There's also the interesting third limb, though, which allows the court to give declarations as to the lawfulness of past or future actions in relation to P. Now, I'm interested in any experiences that people in the audience have had about this, but Tim and I have not been able to find very much, and we certainly haven't come across ourselves, very much case law on just what that means. Now, questions of capacity at certain points, it's quite simple as to what the court's jurisdiction may or may not be. But what if, for example, you have a P who is said to have exercised a power to appoint a new trustee or to exclude beneficiaries of a trust at a point when there's doubt as to whether they retain capacity or not? Can the Court of Protection pronounce upon the lawfulness of that act? If it can, what are the ramifications of that in the context of there are some seats, if you just go right across there, sorry, the people who just arrived. What are the ramifications of the Court of Protection pronouncing on that, if it even can, for third parties who might be affected by it? But I think there's another question as to whether, in fact, the perhaps quick first reading of Section 15.3 is correct. Because is that an act that's taken place in relation to P? Well, it's an act that P has purported to take, but isn't it an act in relation to P? Is that not thinking about, for example, whether someone who has a power of an LPA, who's purported to take steps towards P was able to take those steps insofar as that turns on whether or not P had capacity or not. But there's an interesting scope for argument and confusion there, I think. Over and above that, the court, of course, has the power under Section 16 either to make decisions for P or to appoint a deputy to make those decisions for them. One of the things over which the court has jurisdiction in respect of decisions is, as we put on the slide, Section 18, subsection 1, subsection J of the Mental Capacity Act, the exercise of any power vested in P, whether beneficially or as trustee or otherwise. So any power in Tim's structure that's vested in P can be exercised by the Court of Protection. Well, all sorts of issues arise then. What if a power is exercised by the Court of Protection to appoint a new trustee to exclude a beneficiary who's been beastly to P when P's lost capacity? Is that a decision that the excluded beneficiary can challenge in the Chancery Division or in other courts if it's a decision that's been made by the court for P, either legally and technically or as a question of substance and practical fact? And what sort of people are going to be assembled in front of the Court of Protection, perhaps, when that decision is made? Beyond that, of course, then there's the jurisdiction to hire and fire attorneys and deputies, which I think many in the audience will be very familiar with. But again, those are important potential tactical tools that could be pursued by certain groups jostling in the power struggle that we've already said so much about. Is the first step that you pursue going to be an attempt to get someone knocked out as attorney because you think that they're going to be exercising the powers that are vested in them in a way that's deleterious to your interests or your faction's interests? The penultimate bullet point on the screen considers the scope for interim orders under Section 48 of the Mental Capacity Act, and those interim orders can be made, effectively it's early decisions or early authorisation of early acts, notwithstanding that you yet to determine perhaps even whether P's yet lost capacity and other issues that may arise in the Court of Protection proceedings. But the test is whether it's in P's best interests for a decision to be made on an interim basis. And so you can readily see there might be arguments about whether it is in P's best interests to get trustees out of office who are perhaps being criticised for the way they've been conducting things by one or other faction, before, in fact, there's been a final determination of the proceedings. And then the final bullet point for your consideration on this page raises the question of the scope for injunctive relief. So stopping people who've apparently got a power of attorney from acting until the proceedings have run their course, or potentially stopping, it's not just stopping them acting full stop, but it could be tailored to stopping them carrying out particular acts where there may be said to be a risk to P in the event that the proceedings go one way or another. In that latter regard, Tim, where does that take our consideration of potential fora for these issues to be aired?
Yeah, so there are sort of lots of potential avenues if you step outside the Court of Protection, because one of the key things about the Section 48 power is, again, you've got to establish reason to believe that P lacks capacity. Well, that is obviously a relatively low threshold, but it may well be the case that you're not sufficiently confident that you're going to even get over that threshold. But it may be that, for whatever reason, you don't think that the Court of Protection is a useful place for you. It may be that you're seeking relief which the Court of Protection simply does not have power to give. And in those circumstances, the Chancery Division, the Company Court specifically, or if you've got an offshore trust or offshore company, any offshore courts are the place that you're going to most naturally go. That also is worth remembering if you are a trustee and you start worrying that your patriarch, matriarch has him or herself started to lose capacity. Should you be going to your court, whether in England or elsewhere, to seek directions in respect of what will happen? Because you really do not want to be in a position where you have a person whose capacity is under question exercising a power, and then you are having to decide in quite fractious circumstances whether or not you should be following it. The correct response generally, sweeping statement, would be to try to go to court in as neutral a way as possible and seek directions at that stage, rather than letting things come to a head.
Just to jump in there, we're very much not focusing on the international elements that can arise. But one of the important things to bear in mind is that the Court of Protection, its jurisdiction in relation to these matters is territorial. And so if you've got an offshore trust, it's not going to be concerning itself with that at all. And technically, you're going to have to effectively be relitigating the substance of the same issues as to capacity, potentially very different ones, because you could be concerned with capacity to do different acts in offshore jurisdictions, foreign jurisdictions, which may not have a sophisticated an understanding of these issues, and also may well not have anything like the Mental Capacity Act in terms of a tool to feed the substance of the tests that it should be providing.
I mean, you may well find that the test in whatever offshore jurisdiction is effectively Banks and Goodfellow or some similar thing. The test in England may well be the test under the Mental Capacity Act. It's certainly not right to say that those two are the same, and the Mental Capacity Act test in particular is much more multifactorial. Parenthetically as well, we should say that issues of conflicts of laws and jurisdiction in the Court of Protection are really complicated, and there's an absolute dearth of authority. So that certainly is an interesting area for sort of further consideration. But if you have, so thinking about areas of possible problems, as it were, removal of P as a trustee. If P has lost capacity, that itself is a ground for removal as trustee under the Trustee Act. Fine, but do you want to litigate that out in the Chancery Division pursuant to an aggressive application for removal, or is that something that you want to have resolved in the potentially less fractious forum of the Court of Protection? Do you want to appoint a receiver over his powers? It's quite a nuclear option, I think. It often involves creditor situations, but one of the things we haven't talked about is that P may well himself or herself be subject to attacks from third parties, creditor third parties, which put pressure on the structure. It can be that that's a way in for third parties to get power over powers that P has, in like the TMSF case, and where you've got a creditor having a receivership appointed over a power. And that is something which you want to try and stop third parties from having. Again, the Court of Protection and its more best interest focused forum may be a better jurisdiction for that. But if you're a third party, obviously the Chancery Division is more natural. Applications for directions as trustees, I've already mentioned that. That can often be particularly for trustees, but not just for trustees, for worried beneficiaries, worried children, people who worried their house might be taken over if one of the baddies in the family gets control of P. That might be something that they can do, go to their court, get directions and try and sort out, whether under Talata or pursuant to the court's inherent jurisdiction over a trust. On the corporate side, claims concerning the construction of Articles of Association. If P's lost capacity and the Articles of Association say that you can't be a director or you can't exercise powers if you've lost capacity, do you want a simple declaration that that provision in the Articles of Association has been triggered? You don't need the Court of Protection for that, you just need a Part 8 claim in the Companies Court. Enforcement of quasi-partnerships, I'm thinking Section 994 petitions there. If what is actually happening is that P or those who have, looking after their own interests, have gained control or influence over P, are exercising powers of the company, it might be that other family shareholders should be thinking about Section 994 petitions by way of relief to enforce or protect any quasi-partnerships there might be. And of course, breach of duty. If really what's happening is that there have been breach of duty by people who used to be subject to P scrutiny and they've just gone off on follies of their own, directors in particular, but potentially trustees, that's a useful forum.
But with all of those, you've got the problem as well. If P has to be a party to the proceedings and there's a question over their capacity, you've got that horrible procedure whereby you're going to need a litigation friend in, or you're certainly going to be prudent to try and get a litigation friend in to avoid some sort of satellite dispute as to who the litigation friend should be in advance that's going to totally derail proceedings involving your hostile third party.
Yeah, and that's a really interesting point, because while the Court of Protection can appoint litigation friends, you don't want to get sucked into satellite litigation in the Court of Protection over the appointment of a litigation friend. That said, we've just seen, I saw the first instance decision of Chief Master Schumann preventing a litigation friend being knocked out by the other side. I saw, I think, leading counsel for one of the parties posted on LinkedIn that Mrs. Justice Bacon had overturned that decision on appeal. I've not seen the decision, but you're already seeing, I think, even in the Chancery Division, parties attacking litigation friends as a way of trying to affect the running of litigation in these situations where capacity is an issue. So it may not even be a knockout point.
Just one little diversionary war story on that from last year. I had a client who was, broadly speaking, compos mentis and as sharp as they'd ever been. But their health was up and down, and they were in hospital for some pretty serious heart treatment. And they were on all sorts of drugs, and there was a period when they did not have capacity to do anything sensible. Yet there was quite urgent and pressing need to initiate proceedings relating to their private affairs, private semi-business affairs. And we ummed and ahed a great deal as to what we should do, because we couldn't be confident that actually, when the proceedings were issued, they would not have capacity. And so we, out of an abundance of caution, went through the process of getting a litigation friend appointed on the basis that they were going to act effectively jointly with our client, with P for present purposes, in order to ensure there could be no question that where it was our client's son, there could be no question that they were on the same page, and at the same time there could be no question that proceedings had been properly instituted, could be properly run at any point, because the other side had been, even before our client unfortunately went into hospital, had been casting all sorts of aspersions about his capacity as a particular litigation tactic, because they thought it was just going to bog things down and make things difficult for us.
It's interestingly, this I think is a real growth area. The new Chancery Guide, which is currently being rewritten, is going to have a section on litigation friends, which is much more fleshed out. I know that because I wrote a lot of it. Then the last point is previous transactions, undue influence, lack of capacity. Ed's already looked at the Court of Protection situation. But again, this is a really interesting point in terms of whether when and where you're going to see the attacks. Is actually what you're going to bring an undue influence claim while P is still alive? Are you thinking about trying to bring lack of capacity challenges on the common law Rebini test? Is really what your complaint is that somebody's tricked P and you don't like it? Again, that's fundamentally just a misrep claim in the Chancery Division.
So, as we've said, there's all sorts of strands and threads here which are going to be very, very, very case-specific, depending on the particular structure, the particular characters, and the particular history that you're presented with. One of the interesting features, though, of Court of Protection proceedings, certainly, is the need to be full and frank, and therefore the prospect of all sorts of documents going to people who are parties that in ordinary adversarial litigation you wouldn't dream of sharing with them, certainly at the point in which the documents might be shared. So what sorts of issues can arise and opportunities can arise there, Tim?
Yeah, I think this is a really fascinating and, again, quite under-litigated area. So first point is the point Ed's made. Rule 1.42F, trips off the tongue, of the Court of Protection rules requires a duty of full and frank disclosure on litigants, just generally. So you have this actually extraordinary onus on parties to be full and frank when they're engaged in the Court of Protection. You can absolutely see why that is, because you're looking at P's best interest. You're not primarily, although obviously collaterally you do this, but you're not primarily worried about private law rights. You're worried about P's rights and how the court's decisions might affect P's rights. That leads you, as Ed says, into a situation where you may well be disclosing documents to the Court of Protection which would not be disclosable in similar litigation before other courts. But once they're out, and once other parties, family members, trustees, whatever, have seen them, it's going to be very hard for them to be unseen. Equally, though, there are collateral use rules. The usual collateral use rule apply. There's very likely to be privacy orders in the Court of Protection. And even if there aren't privacy orders, the strictures of the transparency process under Practice Direction 4C will apply, and that does to a certain extent, or a very great extent, prevent you simply going, oh, I found these documents in these other proceedings, here they are, aren't they terribly interesting and helpful for me? Now, the way to get in from the outsider's perspective, i.e. somebody who wasn't a party to the Court of Protection proceedings, is by Rule 5.9, which effectively allows you access to the court file. That has been subject to some quite interesting litigation. AB is a case where the police sought psychiatrist reports of an individual whom they alleged had committed child sexual offences, but who was subject to the jurisdiction of the Court of Protection. 2019 decision reported in 2021. Really interesting, only about 17 paragraphs, but the Court of Protection basically said, no, you can't see it, none of this is relevant to the alleged offences, very focused on P. And the key point, I think, is the parties have to feel like they can empty their pockets, that they can really bare their soul to the psychiatrist, to the court, without fearing that those same documents will be turned up later in an aha moment, in that context to the police, but it's not obvious why that wouldn't also be the case to trustees, other family members, and other courts. Z, though, which is the case Ed and I did, was a case where there'd been long, very acrimonious Court of Protection proceedings that had been settled, and the court made a final order, among other things, declaring P lacked capacity, making declarations as to LPAs, etc. A son who wasn't involved in the proceedings later came along and applied for access to the entire court file. Now, the court said no, largely because the court considered that there were avenues via engagement with his family, etc., which would enable the son to get access to those documents, and that they considered that he had a chance to get involved in the Court of Protection proceedings in the first place. But that was quite a strong decision, which I think surprised many practitioners who tended to think that family members should be given access to Court of Protection information, particularly where you have a finding as to capacity. Permission to appeal was granted, and the appeal was settled before the hearing. While it's a strong decision, I wouldn't be confident it's one of those ones that will necessarily stand up to the test of time, but it is a really important decision. But I think what it shows you is there's a real tension in the Court of Protection between, on the one hand, maximising the ability to be really open in the Court of Protection and therefore keep the proceedings closed, but also to try and engage family members as much as possible. Why be secret? These are family affairs, we need to be open, we need to make sure that P is in the best possible position. And that, I think, does give you an opportunity, or potentially could give people an opportunity to start trying to get hold of those documents from those proceedings for use elsewhere. As I say, I think a really open question as to how that jurisprudence is going to develop probably in the next few years.
I mean, we didn't act for the applicant in that case, but the applicant had, at least at first blush, a very sympathetic story to tell. I was not actively involved in the proceedings that resulted in my father being declared to be incapacitous, and these people who are now running his life and affairs and putting all sorts of restrictions in place that I don't like, being appointed. And I want to see what happened and why and how. And he was told he couldn't for the good reasons that Tim's outlined.
Yeah, but I still think a slightly surprising decision on its facts. But it's, well worth reading that decision of Mr. Justice Morgan. But that sort of gets us then to sort of the big picture of what you do next. And I think it's a really complicated question often as to where you go first, what you do. It's a multifactorial case in all situations about how you're going to approach it.
The big issue, practically, going back to the structure that we outlined at the beginning, though, is that the first priority is often going to be to secure the assets. Because it's all well and good getting a Pyrrhic victory further down the line, but if control has been dissipated, or assets have been taken out of the structure, or the structure's been altered such that it becomes impenetrable, even if you win at the end of the road, what you need to do is you need to stop that happening, and you need to go full circle. You need to be in a position whereby you can take as much control as you can as early as possible. And so the big test is probably going to be which court is going to give you as much control over the key parts of the structure as you can get as quickly as possible. But one of the problems that family members, where you've got a strong matrix, really lies, and that practically, at least in the early days, is one of the big challenges, isn't it?
It is, yeah, and I think certainly early stage, even before litigation, it's often a sensitive use of medico-legal experts. I think getting good capacity people in early, getting them to know P so that P feels comfortable, and making sure you make decisions with P as much as you can. But equally, that's often a counsel of perfection. Sometimes the problem is that P has been isolated by people who don't necessarily have his best interests at hand, and then you face a really difficult decision.
And Helen Galley, who has a wealth of experience in private client and court of protection work and combines legal brilliance with practical and accessible advice, and an irrepressible drive. She's going to kill me after this, you realise. An irrepressible drive to get the job done and to get the right result for her clients in every case. She is going to untangle some knots for us.
There are quite a lot of cases on interpretation of wills, and in 15 minutes or just over, because fortunately Edward and Tim finished a little bit earlier, I can't deal with them all, but there is a paper which accompanies this talk, which is longer and which has some of the other cases as well. But we start with Marley and Rawlings. Everything these days seems to start with Marley and Rawlings. And we know that when you're construing a contract, you construe it in the light of the natural and ordinary meaning of the words used, the overall purpose of the document, any other provisions of the document, the facts known or assumed by the parties at the time that the document was executed, and common sense. But you ignore the subjective evidence of any party's intentions. Mr. Justice Lord Newburger said that when interpreting wills, the same approach should be applied, and they could see no reason why the same approach should not apply. Of course, a will is a unilateral document, but again, he came to the conclusion that that distinction is an unconvincing reason for adopting a different approach in relation to interpretation of wills. So wills are going to be construed in the same way as contracts, but with little extra wrinkles, because there are some statutory provisions which we have to bear in mind, and the first of those is Section 21 of the Administration of Justice Act 1982, and I know there's an I missing out of administration. It wouldn't be a talk by me if I didn't make some typos. I am the worst typist that's ever put their fingers on a word processor. So Section 21 of the Administration of Justice Act modifies Marley to a certain extent, and the section applies to a will only insofar as any part of it is meaningless, insofar as the language used in any part of it is ambiguous on the face of it, and insofar as evidence other than evidence of the testator's intention shows that the language used in any part of it is ambiguous in the light of the surrounding circumstances. And in that case, and only if those situations apply, then the extrinsic evidence, including evidence of subjective intention, will be admitted to assist in its interpretation. So in the light of those principles, we'll look at some cases. And the first of them is Margaret Burns as executor of Daisy Bean deceased against Karen Bean. This was a decision in 2021 of Master Clerk. And probably there is a proliferation of interpretation cases because masters are dealing with more trials and decisions of masters are becoming more reported. So in this particular will, there was a provision that my trustees shall then distribute the balance remaining, so as the residuary estate, equally among all of my children who are alive at my death. There were 4 children. One of them, George, had died before his mother, and he had 5 children, some of whom were minors. So the question was, was the residue divided between the ones who'd survived or the ones who had survived plus the children of George? Well, if you look at it, on the face of it, you would think that the answer was probably pretty obvious. But it isn't. Because you have another statutory provision to take into account, and that's Section 33 of the Wills Act. And that provides that where a will contains a gift to a child or remote descendant of the testator, and that one of the intended beneficiaries dies before the testator leaving issue, then the issue of the intended beneficiary are living at the testator's death, then unless a contrary intention appears by the will, the devise or bequest shall take effect as a devise or bequest to the issue living at the testator's death. And the same applies if it's a class gift. If it's a class gift to all my children who survive me, again, if one dies before the testator, then so long as there is no contrary intention in the will, the issue of the deceased member of the class will take the provision which their parent would have taken. Now, one wonders how you show a contrary intention, if not by saying to such of my children as survive me, but That is something which doesn't seem to have worried the courts terribly much. So in Ling and Ling, the provision was as set out on the slide, so very similar to the provision in the Bean case. Upon trust for all or any of my children living at my death or at the expiry of 1 calendar month therefrom, who attain or shall have then attained the age of 21 years, and if more than one, as tenants in common in equal shares absolutely. Well, Mr. Justice Etherton held that the words living at my death achieve nothing, and were only there to state expressly what would otherwise be implicit, namely that a class is normally composed of those members, if any, existing at the date of death of the testator. They gave, he held, no indication of any intention that a child's issue should be excluded from taking the child's share under section 33(2). We then came to Rainbird and Smith. Now, Rainbird and Smith, again, another similar provision, residuary estate upon trust for such of them my daughters, the said Jacqueline Anne Rainbird, Janet Jones and Gwendolyn Smith, as shall survive me, and if more than one in equal shares absolutely. That was an unopposed claim for rectification of the will. But the judge, John Baldwin, sitting as a deputy judge, decided that it was necessary to construe the will before considering whether to rectify it. And he said that the testator's intention was perfectly clear, and that it was that only those that survived, only of the 3 named children who survived the testator should take a share. He distinguished Ling on the grounds that Mr. Justice Etherton had commented in that case that the will was very poorly drafted, awkward, and grammatically inept. So there we have 2 conflicting cases. Then comes along Hives and Machin. Again, very similar provision. Residuary estate, upon trust for such of my sons, Peter David Machin, Eric Wilhelm Machin, and Christopher Bastube, who shall be living at the date of my death, and if more than one in equal shares, absolutely. Mr. Timothy Famcourt, as he then was, sitting as a deputy, rejected the submission that the only task was to construe in accordance with the principles set out in Marley. He identified that the proper question was whether there was a contrary intention for the purposes of section 33(2), and came to the conclusion that there was nothing there. The words of clause 5 should be given their natural meaning, but neither they nor other terms of the will show any contrary intention for the purpose of section 33. And he was reinforced in that by the views of Mr. Justice Etherton in Ling. And so Master Clark had to come to a decision, and she came to the conclusion that the will was not ambiguous, that on its face it meant that Mrs. Bean's estate should be shared equally by all the children who survived her. But you've got to look at section 33(2). So the question that she's had to answer was there a contrary intention? And she came to the conclusion, relying on Ling, that there wasn't. So if you are drafting a will and you want the residuary estate to pass only to those children who survive the testator and not to any deceased children's issue, then you've got to really express it very, very clearly, because just by saying that it's to go to those who survive won't do. You've got to do something more than that. So that can be quite important when you are thinking about drafting a will. The next case I want to look at is Partington and Rossiter. This was a case in the Court of Appeal in 2021. And the testator's will stated that it only had effect in relation to his UK assets. But at his death, he had substantial assets in Jersey and no will in Jersey. And so the question was, did the UK assets include his assets both in the UK and in the Channel Islands? And the judge at first instance found that it did, and the widow appealed because she would have taken those Jersey assets if they didn't pass in accordance with the will, because she would have taken them on intestacy, and the appeal was dismissed. What was said was that the dictionary and statutory definitions of the United Kingdom excludes the Channel Islands, but it can, in a private instrument, include the Channel Islands, depending on its context and the interpretation of the document in question. And what the court is striving to do is to give effect to the testator's intention and purpose as expressed in the will. And the court will always try to construe so as to avoid an intestacy or a partial intestacy. So looking at the surrounding circumstances within section 21(1)(c) of the 1982 Act included any way in which a reasonable reader would understand a will, save for evidence of subjective intention. So in this case, there were two possible interpretations. One was inclusive and one was exclusive. So either UK meaning United Kingdom, excluding Northern Ireland, because Northern Ireland is not part of the UK, or it would include the Channel Islands, because it was used in a colloquial sense. And it was unlikely that the deceased had intended to die intestate. So Mr. Justice Lewison said, "It had long been a principle of interpretation that if one realistic interpretation would result in the contract being valid and another would result in it being invalid, the court would prefer the one which meant that it was valid. Equally, the court would try to interpret a will so as to avoid intestacy either in whole or in part. The will was ambiguous in the light of the surrounding circumstances, and as a result, evidence of subjective intention was admissible. And in that case, it was clear from the subjective intention, including all the relevant documents, that the testator intended that the reference to his UK assets would include his assets in Jersey. So in that case, the widow lost out, and the beneficiaries under the will were successful. The next case is Royal Commonwealth Society for the Blind and Besant, and this is a case involving an interpretation of a gift of a nil rate band sum. I hope that nobody in this room drafted this will. But it was pretty appalling, really, because what the provision of Clause 4 was that I give the nil rate sum to my trustees on trust for my son, John Besant. And then there's a definition of what nil rate sum means, and it's quite a common way of expressing it. The largest sum of cash which could be given on the trust of this clause without any inheritance tax becoming due in respect to the transfer of the value of my estate, which I'm deemed to make immediately before my death. And that formulation is often used because the person drafting the will doesn't necessarily know whether the testator has made any lifetime gifts which are going to be brought into account and which will count against the nil rate band. But Mr. Besant was the defendant in this claim, and the claimant was one of 21 residuary beneficiaries, 20 of whom were charities. And the gifts which followed the gift of the nil rate band sum were expressed to be free from tax. And then there was a provision giving pecuniary gifts, and they were all expressed to be free from tax. So where the tax was to be borne, goodness only knows. So the question was this a gift of £325,000, or was it a gift of what was left of the nil rate band, having taken into account the value of the other gifts? Because, of course, the charities could not be made to pay the inheritance tax because they are exempt. And the other gifts were expressed to be free from inheritance tax. The case was very similar to the case of RSPCA and Sharp in 2010, where the defendant argued that the will should be construed omitting Clause 4.1, and if that did not find favour, pointed out that Clause 4.1 did not mention the other nil rate gifts in the will. Well, the master concluded that if the testator had wanted to make a gift of £325,000, the will would have said so. That was a straightforward thing to do. Equally, it could have been worded as a gift free from tax, but it wasn't. And the clause demonstrated an understanding of how IHT is chargeable, but obviously didn't display an understanding of how it would work in the context of this particular will. She did not accept that the words were superfluous or OTOs and found for the claimant, so poor Mr. Besant got nothing. Jacqueline de Silva and Sandra Heselton is a case on the interpretation of a charging clause. And I find this one quite an interesting case. It was a decision of David Rees sitting as a deputy judge on appeal from a decision of Deputy Master Lloyd. And it was a pretty standard form charging clause. So it provided that in addition to the powers under the general law, there was power for any of my trustees who shall be engaged in any profession or business to charge and be paid in priority, etc., all usual professional and other fees, and to retain any brokerage or commission for work, business introduced, transacted, or time spent by him or his firm in connection with the administration of my estate or the trust powers provisions of this will or any codicil. And that would include work or business outside the ordinary course of his profession and work or business, which he could or should have done personally had he not been in any profession or business. Well, lo and behold, Mrs. Heselton was an executor and trustee of the trust and was involved in a business which was totally unrelated to the administration of trusts and estates. So the question which arose was whether she could charge for time spent on the administration of the estate. And we all know, general rule, a trustee must act gratuitously. So a charging clause is the ability to charge is an exceptional right, and a charging clause will be construed strictly. So the general principles of interpretation set out in Marley and Rawlings. So far, so good. So the judge then looked at the specific words used in the will. And he agreed that the words were potentially capable of applying to a person engaged in any professional business, even if the scope of that professional business has no connection with the administration of the estates. But he then went on to say, the ability of a person engaged in such a profession or business to charge under this clause is not unconstrained. They may only charge all usual professional and other fees, and those usual fees must be for work or business done or time spent by him in connection with the administration of the estate. He went on to say that it was the inclusion of the words usual, professional, and other fees which was key to understanding how the clause worked. They govern not only the amount of fee which could be charged, but also the nature of the work for which the fee could be charged. And so the natural meaning of the words required you to look at the work done and consider whether in the professional business of the trustee, a usual professional or other fee could be chargeable. So if a trustee's profession did not involve the management or administration of a trust or estate, he could only charge if a charge for the particular work or business done would arise in the usual scope of their professional business. So this is in contradistinction to a solicitor who can charge for any work that they do in connection with the administration of the estate. So you might have, for example, an estate agent who is appointed as an executor of an estate with a charging clause such as this. They could charge for selling the real property or letting the real property of the estate, maybe even for doing other work in relation to that property, but they wouldn't be able to charge for other actions which a solicitor could charge for, because the work of selling the house, etc., would be work which they could do in the course of their trade or profession as an estate agent, and so they were entitled to charge for it. And you can see the reasoning behind all of this, because, for example, if you appoint a hairdresser as the executor of your estate, and you have a provision such as this, should the hairdresser be able to charge for the time that they spent in administering the estate when that was something which is completely unrelated and for which they could not charge for in the course of their business as a hairdresser? Well, clearly not. So that is understandable in the context of these things, but it is something which, when drafting wills and when appointing people to certain positions, is necessary to consider. So that is a very quick gallop through 4 of the cases. There are quite a number more which I dealt with, as I say, in the separate paper. Thank you.
So we're going to stay on the topic of wills, and now we're going to hear from Bajul Shah, a force to be reckoned with. Some say he is a brain on a stick, but as you can see, he is so much more than that. He is going to take us abroad in more senses than one, I apprehend, because he is going to take us into the heretical world of oral wills.
Now, if you thought Helen's talk was not contentious enough, that written wills don't throw up enough problems, I'm going to throw the cat amongst the pigeon and suggest that actually oral wills are the way forward in this. But the first question is going to be, how do you recognise foreign oral wills? Before I get going, has anyone had experience of foreign oral wills? No? Anyone too shy to put their hands up? Okay. I mean, most states do not actually permit you to make an oral will, but there are a surprising number of exceptions. In England, under Section 11 of the Wills Act 1837, preserves the right of soldiers and people in the Marines to be able to make oral wills when they are in service. About 20 states in the US permit oral wills, including New York and many of the ones on the Eastern Seaboard. Quite a number of former Commonwealth countries do so as well. Many countries in the Middle East, including Qatar, and that's important because that touches on a case that some of us in Chambers were involved in. So not that rare, actually, when you look into it. And as I said, some of the states that permit oral wills only allow you to do so in certain circumstances or certain categories of people, such as those in the armed forces. And many of them impose various formalities for it. So the usual one is that the declaration has to have been made in front of 2 witnesses, and the deceased must die within a short period of having made that declaration. So in Kenya, it's 3 months. In New York, it's 1 month. Some states require you to evidence that particular oral declaration. It needs to be recorded somewhere. Some states require the declaration to be made before a particular person, such as a judge registered elsewhere. That's the position in Qatar. Now, that's a sort of, if you like, a roundup, if you like, of the sort of situations one can come across around the world. What I want to focus on is the circumstances when a foreign oral will can actually be recognized in England. So I'm not going to talk about English oral wills made by members of the armed forces, and I'm not going to talk about deathbed wishes made in England, so the donatio mortis causa situations. And what this topic really engages is the confluence, if you like, between concepts of conflict of laws and probate. It's where the two collide that we're really involved in. So, can you obtain a grant of representation in England in respect of a foreign oral will? And the answer is yes, you can. And the mechanism by which we do it in non-contentious practice is through the non-contentious probate rules. It's Rule 30. Now, Rule 30 is not specifically designed for oral wills. It's actually designed for all foreign wills. But that's the mechanism you use for this. Now, actually, a lot of the learning in this area doesn't come from the non-contentious rules. It comes from contentious probate cases. But the non-contentious rules essentially envelop the learning that you'll get. And I'll touch on how that applies. So the sort of situation we're envisaging is one where you have foreign domiciled testators and you have movable property in England. That's the usual scenario. There is a little bit of complication in relation to land. There always is complication in relation to land in England, and I'll touch on that briefly. But the typical scenario we're involved in is foreign domiciled testators and movable property in England, so money's in a bank account. And the key test is that the oral will, must be admissible to proof in England and Wales. And that concept, admissibility to proof in England and Wales, encapsulates our conflict of laws rules. And there are 3 situations, 2 common law, 1 statutory. So the first common law rule is if the courts of the deceased's domiciled have admitted the will as valid. That's the first situation. So if where the deceased was domiciled, if the courts of that state have ruled on the validity of the will, then that oral will can be admitted to probate in England. There's a very long-standing line of authorities from that. There's a House of Lords from the mid-1800s called Doglioni and Crispin. And in that incredibly self-confident way of the 19th century judges, you have no principle can be better established, etc., etc. In fact, there are errors in that principle. You'll see that in the first line it refers to administration of personal estates. Actually, it's not just administration, it also applies to succession as well. It talks about, in the second line, about things belonging exclusively to the courts in which he is domiciled. That can give the misleading impression that you have to litigate things in the courts of the deceased's domicile. It's not quite like that. But, let not accuracy get in the way of confident assertion of principle. So Doglioni and Crispin, and read Truffaut, which actually has a much more accurate description of what's going on. Now, I'm not going to talk about the facts of those 2 cases. I'm actually going to talk about the Althani case for 2 important reasons. One, because members of chambers were involved in Althani. So Edward Cumming, Stephen Moverley-Smith, and myself were involved in. So far more important to talk about that than the other 2 cases. But actually also because Althani is one of those rare cases that actually involved an oral will. And so the circumstances were these. It involved a member of the Qatari royal family, Sheikh Saud. At one point, he was actually a minister of, I think, arts and antiquities. In 1990, in accordance with Qatari law and procedure, he attended before a judge of the Sharia court, made an oral declaration as regards his worldwide estate, the disposition of his worldwide estate. That oral declaration was recorded and entered on a specific register, signed by the judge, and the judge then issued a copy of that entry. Now, after he passed away, there was litigation in Qatar between his widow and children on the one hand, who said he died intestate, and so they scooped the whole estate, and certain beneficiaries named under the will who said, we're entitled. It was hard-fought litigation. We weren't involved in it at that stage, but the suggestion was that he died an extremely wealthy man, and therefore there was a lot to fight about. The Qatari courts ultimately held that that will was valid in accordance with Qatari law. So the focus then moved to the BVI. Naturally, of course, Qatar, BVI, why not? The reason, of course, was because his estate included BVI companies, shares in BVI companies, through which most of his assets were structured, and those were incredibly valuable. Now, there is a complex history behind what happened in the BVI, but the essential bits for our purposes were these. Those who had succeeded in Qatar in establishing the will as valid brought proceedings in the BVI for essentially seeking declarations as to the validity of the Qatari will. And the court ordered a preliminary issue to be tried as to whether the judgment in Qatar disposed of that particular question. I'm paraphrasing. And the BVI court on that preliminary issue held that it was bound by the findings that the Qatari courts had come to, and it did so on two bases. The first base was as I put on that bullet point, under the BVI conflict of laws that operated. Now, the BVI conflict of laws are exactly the same as English conflict of laws, and the particular conflict of laws rules was the one I'd outlined earlier, stated in Doglioni and Crispin, namely that if the courts of the state of domicile had ruled on the validity of the will, that was conclusive in the BVI. There was also an argument on issue estoppel, and that also succeeded. Now, the case actually then went on appeal. The appeal court judgment actually only deals with the issue estoppel point, but it's the first instance decision in 2020 that deals with the common law rules. So that's an example where the old doctrine was very much alive and kicking, and that allowed the oral will to be recognized as valid for the purposes of the BVI. So that's the first basis in which a will can be admitted to proof. The second basis is one where you don't necessarily need a judgment of the courts of the domicile, but what you would need is evidence of what the law of the domicile provides for the validity of a will. So if you have evidence that shows that the law of the deceased's domicile would regard that particular declaration as valid, then that will allow you to admit to proof the oral will in England. Now, I've cited a case there called Re Oldenburg, another royalty decision, but this time a different part of the world, Imperial Russia. The evidence in that case, the person who died was a member of the Russian royal family, and they wanted to admit into proof a particular document called an acte définitif. So this is not actually a case of an oral will, but it's illustrative of the principles. Now, the evidence there was quite remarkable. It was that for members of the Russian royal family, a will that they would have made in the usual way is not valid. What apparently happened in Imperial Russia was that after the person died, his heirs got together, agreed on what was to happen to his estate, set that out in writing, and that written document, the acte définitif, was required to be blessed by the emperor. So you have a document that's not made by the deceased, does not express the deceased's wishes, but actually expresses the wishes of other people altogether. But the evidence was that that counts as a valid will under Imperial Russian law. And the probate court in England had no difficulty in admitting the acte définitif to proof in probate. And in fact, what they admitted was the acte définitif as a grant of representation with the will annexed. So those are the two common law routes. Now, the third route is statutory, and that's under the Wills Act 1863. The Wills Act 1863 is a relatively short statute, but it actually has incredible complexity to it. I'm only going to touch on a couple of aspects to it. Sort of, if you like, working backwards, Section 6 is perhaps, I think, the only statutory definition I could find of what might be thought of as a will. And the important words, a will includes, so it's not exclusive, it's inclusive, includes any statutory instrument. This particular statute provides is that if a will, so it's in Section 1, if a will has been executed by a person in accordance with one of 7 different laws, then it'll be treated as valid in England. So the 7 different laws, it's a real options menu here. You've got the law of the place where you've executed the will, either the domicile, habitual residence, or nationality at the time of execution, or domicile, habitual residence, or nationality at the time of death. So this is one of those instances where an English domicile person could actually make an oral will that would be recognised as valid in England. So if they were an English domicile person, if they were habitually resident or happened to be a national of a state that allowed you to make oral wills, and they did so in accordance with that law, that will would be recognised as valid in England. The other interesting thing about the Wills Act, most of the situations that we have dealt with involving foreign wills usually concern movable property. And at common law, an oral will or a will made abroad would only be effective to dispose of movable property in England if the will was compliant with the deceased's domicile. At common law, if you wanted to dispose of land, you had to have a will that complied with the law where the property was situated, the land was situated. So for English property, it had to be an English compliant will. The Wills Act provides you with an exception to this. So you could, so in our example of the English domiciled testator who happens to live in a state that allows oral wills, if he makes an oral will compliant with the law of that state, disposing of English land, that would still be valid. Quite terrifying in some ways. Given all the problems Helen's pointed out with written wills, one shudders to think, well, I suppose we should all be grateful as litigators for that type of scenario. So that's a very sort of, if you like, a condensed view of the Wills Act. The Wills Act is not, if you like, a comprehensive code. So, if you had a foreign will and you wanted to know what it actually meant, its interpretation, whether, for example, it was effective in a case where the testator was subject to, forced heirship type rules, those things you still have to look at common law rules rather than the Act itself. You still have to look at common law conflict of laws rules to untangle that particular situation. So once you cross the particular threshold and worked out that you can actually admit an oral will to probate in England or for it to be recognised, how do you go about it? What are the mechanics of doing so? So a couple of sort of quick pointers. There are situations where you can get a grant of probate for the will without any order of the court. And that's under Rule 30, sub 3 of the non-contentious probates rules. And they're quite restricted. So if the will is in English, then the probate can be granted to a named executor. That's going to be a pretty rare situation with an oral will, I suggest. Otherwise, you can make the grant according to the tenor. So if there's a description in the oral will, I'm trying to work out how that actually works, to somebody who's supposed to administer the estate, then you can get a grant to them. But otherwise, the situation that most commonly pertains is you have to make an application for a grant of administration, and that's under Rule 30, sub 1. Now, within Rule 30, sub 1, there is a sort of hierarchy of people to whom the grant can be made. At the top, it's the people who the foreign court has, for example, recognized and administered, and it works its way downwards. But the list is not exclusive. There is a residual power in our own Supreme Court Act, Section 116, and that was mentioned in the case that I put down there. I'm not going to even try and pronounce the name. I think she was the widow of the oligarch who mysteriously died. So not Berezovsky, but the other one with the unpronounceable name, Patakatsishvili, I think. Yeah. So it was his widow, and the court there made the point that Section 116 gives you a greater power to appoint to anyone else. And that's quite an interesting point because normally, when we deal with matters of succession and administration, we're usually looking at the law of the domicile of the deceased. So usually most questions, things like capacity, what does the will actually mean, Are they subject to forced heirship? Who is the proper person entitled to administer the estate? We usually always focus on the law relating to the person's domicile. But our own statutory provisions have widened the class of people to whom we can provide that. So that is, if you like, a whistle-stop tour through foreign oral wills.
So now we are going to hear from Sarah Bayliss, who's an extremely well-known and well-respected barrister who brings perceptiveness and practicality to the very many cases in the private client arena with which she deals. Her presentation is going to be the opposite of irrelevant, boring, and wasteful, but that is what she's going to talk about. Sarah.
Yes, well, this striking comment, which I hadn't seen before, but was quite taken with a few weeks ago when I was, as usual, looking for something else, is in the Inheritance Act Claims loose leaf, edited by Andrew Francis. And what's particularly striking about it is that it seems that he intends it to apply pretty much to all conduct under all circumstances. Well, that can't quite be right. So let's have a bit of a look further on conduct. You now have my favourite picture. So this talk, there's a long list of things that this talk isn't about.
Is that you, Sarah?
It could be, couldn't it? It's not about good conduct. It's not about executors' conduct or indeed the deceased's conduct. It's about poor conduct of claimants. Now, there's a couple of ways one could look at that. The first one, of course, is that if you are another claimant or your family member wanting to upend a claim, you'll be very interested in everybody else's poor conduct. But the boot could be on the other foot, or you just could have a rotten dust-up where everybody is criticising everybody else, at which point, of course, you'll be driving the court nuts. So part of what's to look at is how not to do that. Conduct, of course, might concern the merits, but it also might concern costs. Here's a very illustrious panel of judges who've just heard me on the merits of something. I'm going to dangerously assume some knowledge about the 1975 Act claim, but worry you not very much. I'm going to talk about the Section 3 factors that go to conduct. You've got 3.1 up on the screen, and then 3.1G, which is a sort of bringing up the rear provision that the court's to take into account any other matter, including the conduct of the applicant or any other person, which in the circumstances of the case the court may consider relevant. So the first thing to grill your enthusiastic lay clients about is whether all the things they want to complain about, and there are usually an awful lot of them, about the undeserving claimant or indeed the equally undeserving other claimant or the nasty family or whatever it is relevant. Now, Eilert and Mitson, which most of you probably will have run across, which is a case about provision, a claim for provision for an adult child, is a good example of relevant conduct. In that case, there was an estrangement, and the judge at first instance concluded that there was some responsibility on both sides for the estrangement. And that was obviously relevant when, years later, a claim was made against the mother's estate. Had the daughter been thoroughly horrible or lacking in moral probity in some way, or possibly a shoplifter or something of that sort, it ought not to have made any difference. So that's relevant. Serious does mean serious. Murdering the deceased being the most obvious example, applied to Helen, I think. Did you? Not now, obviously, but at a further... Yes. You had a... Yes. So that's an example of that. Conduct short of murder might reduce an award, but it probably won't usually overcome a claim altogether. The case that's always cited for that is a case called Ray Snook, which is a family law case. That was, in that case, there was violence resulting in a non-molestation order and denial of access to a child of the marriage, and that reduced the provision made, but didn't eradicate it entirely. And in a recent case called Baines and Hedger, which you see up there on the screen, that was a case for maintenance where the judge found that the application had exploited the generosity of the deceased fairly shamelessly already. Mr. Justice Park said it would be surprising if in the ordinary case conduct alone could exclude an otherwise meritorious claim. An obvious application of bad conduct, or where bad conduct will be relevant, is where that conduct reduces the claimant's obligations or responsibilities under 3.1d. Eilert Mitzen, again, is a good example of that, as is a case called Stephanides and Cohen, in which the court strongly disapproved of what it took to be thoroughly bad behaviour on the part of a son who was a drug addict. So those are all instances where you might rely on bad behaviour. When should you run away and not go there? If all you will achieve is mutually assured destruction by way of irrelevant recriminations, just don't go there. Lambert and Lambert is another family case which is usually cited as a reason not to go there in 75 Act claim cases, just as much as in family cases. And that case refers to the distasteful exercise of measuring the parties' respective performance in a relationship, leading to disputed and often futile evaluations of the contributions in both parties, of both parties rather. Now, you can quite see in terms of provision for spouses or partners that there would be crossover between 75 Act claims and divorce cases, but it also applies equally to family dust-ups generally played out through 1975 Act claims. I think all of us who do those claims would expect the court to take a very dim view of evidence which effectively amounted to a slanging match, no matter how sincerely meant, and it often is very sincerely meant. In Ray Mohammed case last year, the judge commended the parties for not relying on points about conduct, which were plainly quite red in tooth and claw and upsetting for the parties on either side, although it seems that they'd figured large in what the lay clients originally wanted to say and what had been canvassed in the in the evidence. Here's a case that settled, and as it settled, the court didn't make any findings, so we can make some assumptions. So the claimant was the deceased. There'd been, it was fairly clear, although the family didn't agree, that there had been a 7-year, perhaps she said 9-year relationship. So let's assume that was right, and that there had been, let's assume, regular payment for rent and other expenses, although query in the same quantum as the girlfriend sought, or in a different amount. The family, who included the executors, the beneficiaries, Uncle Tom Cobley and all, were quite cross about this. They said, not the deceased girlfriend at all. Well, let's assume they're wrong about that, otherwise she wouldn't have had any locus to bring, and hadn't been maintained at all. So let's assume they're wrong about that, otherwise there'd be no maintenance claim. Was there any conduct, because so far as the family were concerned, this woman could do no right, was there any conduct that might reduce an award? Well, one of the elements of the claim was a promise, she said, to leave her money in the will. Well, let's assume there were some evidential difficulties about that. They also said that the deceased was unwell and vulnerable and she'd basically defrauded him. Let's assume there was... let's assume it wasn't clear how that evidence was going to shake down at trial. And they were also particularly exercised by the fact that she'd enjoyed a number of trips to casinos and spent a fair amount of money considering their circumstances, and gone on some foreign holidays. So was it worth I mean, there was no stopping them, but was it worth the family raising conduct in those circumstances? And if so, what conduct? Well, let's assume some more facts. Let's assume this is a lowish value estate. And let's assume that the claim is relatively modest, say 10-15% of the estate. Say there is some evidence that payments were made to her, but not as much as in the claim. And assume, therefore, that in your sort of kit of things you need to talk to the client about, time is going to be an issue for you at trial, because there's no way on God's earth that it's going to be more than a 3-day trial. So what have you got to get into that 3-day trial? You've got to get through the maintenance claim and establish that there's locus in circumstances where that's challenged. You've got to make all the sums work. The judge has got to make findings on all of the financial information that the claimant has put in. He's also got to make sense of the information or any evidence that the residuary beneficiaries, the family members, have put in about payments, behaviour. Court day is 5 hours. Going to need getting on for a day for closing, maybe 6 hours if the court's going to sit a bit longer. Going to use the best part of a day in opening and closing. Couple of witnesses on each side, quite a lot to get through. Are you really going to want to have to dish the dirt about whether she was a fraudster, whether she took him for a ride, in what particular ways she took him for a ride, what she lied about? Have you got evidence for those things? And there were evidential difficulties in relation to all the points that actually both sides wanted to bring forward. But the gambling's tempting, isn't it? How much was spent on the gambling? Was it all of it? Ask the lay client. Ask my lay clients. I was for the family. They would naturally say it was all wasted on gambling and foreign holidays. Well, supposing the judge is not particularly keen to find that, but he's happy to find that some of it was. Well, what if it's 10%, 20% of her claim? Seems to me that that's an excellent, quite logical ground for a judge to say, well, that's bad behaviour because he didn't know about it. Might need a bit of evidence there. It's quite a lot of money. It's a substantial percentage. It's not nothing. It's not derisory in relation to what's being claimed. I'm going to reduce the award on the basis of that. Now, whether you take that as a standalone point under 31G, or whether you say that under 31D it vitiates the responsibility that the claimant had for, that the deceased had for the claimant, it doesn't really matter. You're still using conduct, I think, in those circumstances in a fairly concise and time-efficient way, because the family had, or the claimant discovered pre-litigation some of her bank accounts, and you could work out some of the spending of gambling on that. So, you know, rather than having to put the clocks back or disappearing into its black hole and sending the judge off to sleep, Francis is wrong. Conduct can be very helpful, either to bolster your case or to spoil somebody else's. But it doesn't do to go on about it if it's not relevant. You're going to have everybody's going to doze off under those circumstances. Now, I've probably pretty much used up my time. I don't want to say much about costs, save to say that the decisions that one makes in deciding how to run the case are very likely to sound in costs under CPR 44.4. Was it reasonable for the party to raise, pursue or contest a particular allegation or issue? Has somebody exaggerated their claim or indeed their defence? The enlightened professionals who were dealing with the Mohammed case obviously persuaded the family members in that instance that discretion was the better part of valour. Thank you very much.
We welcome to the stage the extraordinarily intelligent, ferocious, tough-minded and punchy Adam Cloherty, who is joined by one of our recent and brilliant recruits, Harry Samuels, who obviously has a sparkling career ahead of him. And they are going to address the issues which modern families throw up for us all in trust structures.
We are, in fact, going to address the ways in which human rights and equality considerations can impact on the interpretation of trusts, wills, and similar instruments. And what we're going to do is this. We're going to do it by reference to a recent case called Goodrich against AB, in which I acted for one of the parties. We'll start with some background about that. We'll then scope out the relevant issues in the case. And then, once we've done that background, I'm going to hand over to Harry, who's going to do all the important intellectual heavy lifting, and he will explain what the law is, how it was applied in that case, and then we'll have a little chat about some of the implications of it. So, what do we need to know about the underlying facts of the case? Not very much for our purposes. It's all centred, and this particular decision is part of a much wider set of litigation about this trust. But this part of the case revolved around a 1990 EBT, Employee Benefit Trust, in relation to the famous Walker Books empire. And it was a trust essentially for the employees and family members of the employees of the group. The date 1990 is very important. Lodge that in your heads. The EBT held about 51% of the group's shares and subsequently came to hold the proceeds of sale of those shares. And the trustees wished, once the proceeds of 65, or does it mean something else, etc., etc. So we're not going to deal with that part of the case, although we will touch briefly on the relevant principles, general principles of interpretation, because they turned out to be quite important. What the case was really concerned with, or rather the bit that we're going to talk about was really concerned with, were the words spouses and children. And what did that mean? It arose because, or the questions arose in relation to spouse because, the question was, does spouse in this 1990 instrument, so long before marriage of same-sex couples was within English law, did spouse include those same-sex spouses? Of course, under the Same-Sex Marriage Act 2013, the new law of England and Wales, which is that marriage includes the marriage of same-sex couples and opposite-sex couples, only applies prospectively, and it only applies to instruments that take effect on and after the coming into force of the Act, which is in March 2014. And for good measure, the provision in the bullet point, which is shoved at the back, that's normally where you find the most offensive provisions. I think it's in paragraph 1 of Schedule 4, I think. But that means that although the government changed the law prospectively, it does not have effect on pre-existing instruments. Another issue in the case, which we're going to touch on, or rather Harry's going to tell you all about in a minute, is did spouse in the EBT extend to civil partners? You'll all know that civil partnerships are not marriages and civil partners are not spouses as a matter of common law. And indeed, the legislation, although it grants a kind of legislative equivalence between civil partnerships and marriage, doesn't generally alter the definition of spouse to include civil partners. But you may recall, because it was very widely publicised at the time, a case called Steinfeld and Keedon in the Supreme Court. And this was the case which led to the government being forced to extend civil partnerships to opposite-sex couples. Previously, of course, it was restricted only to same-sex couples. And in that case, the Supreme Court decided that it was a fairly flagrant breach of the non-discrimination provisions of the Human Rights Act to say that only same-sex couples could have civil partnerships. And it was discriminatory in essence because, as the claimants in that case successfully argued, many people have a completely legitimate desire not to marry because of their genuine political, philosophical value belief that marriage is a patriarchal institution, but they still want to access the rights and entitlements and maybe the obligations that come with being married. They just don't want to use the M word. And then the third issue was, does children extend to stepchildren? As you'll all appreciate, I am sure, at common law and indeed in the various statutory manifestations of the word child or children, that does not include stepchildren. And so it was my job to argue in relation to all of those things that the court should adopt the widest possible interpretation of the words, so that spouse should include same-sex spouse, whether or not the instrument predated or postdated the Act. So in our case, the 1990 EBT, spouse should still include same-sex spouses, that spouse should also include civil partnerships, and that children should include stepchildren. And now Harry is going to explain what happened and why.
Let's swap over. Let's do a sort of seamless transition. So before we get to the decision itself, which is a decision of Chief Master Sherwin, there are some important aspects of the law as it previously stood, so some cards already in play that we need to be aware of in order to make sense of what actually happened. And I'm afraid to say to a room full of private client lawyers, that requires us to look at the Human Rights Act, which is something that certainly I had not really seen before in this context. So the key principles of the Human Rights Act that are engaged here are both the substantive rights conferred by the incorporation of the European Convention, but also, and quite interestingly, the exact mechanism by which they have been adopted into the domestic law. So sections 3 and 6 of the Human Rights Act tell the courts and tell public bodies how the convention rights are to be applied. So section 3 is that legislation must be construed as widely as possible in concordance with the convention. And section 6 defines the court as a public authority, which means that it must act in itself in compliance with convention rights. So those are the two key mechanisms by which the convention is incorporated. And then we have the rights themselves, which is Article 8 and Article 14 in conjunction, which create obligations to respect private and family life, and the courts must do that in a way that is non-discriminatory. So that's the rights framework that we have in place. We also have some previous authority on this, which is a first instance decision from 2017, which is the case of Re Hand's Will Trust. Now, this was a decision by Mrs. Justice Rose, as she then was, and of course is now in the Supreme Court. And in that case, what happened was a will trust made provision that the residue of an estate should go to the children of the testator, and then in turn to their children, and using the word children. Now, at the time that the will was created, the Adoption Act 1926 was in force, which essentially said that adopted children did not count as children when construing legislation. Now, as it turned out, one of Mr. Hand's children had adopted further children. And so when it came to construing the trust that he had set up with his will, that adopted child brought a claim to the court seeking to argue that it would be against his convention rights to construe the will trust as excluding him because that would discriminate against him. Now, Mrs. Justice Rose in that case found that it would so discriminate. And that is the springboard that we have for diving into this case. And the reasons that we have in this case substantially follow those given by Mrs. Justice Rose in that one. So let's dive into the decision. And as you can see, on the spouse issues, Chief Master Sherwin said that the expansive definition should be applied, and that the children issue, unfortunately, does not include stepchildren. Now, the reasons for that are essentially twofold, and there are reasons of traditional construction and reasons of applying the Human Rights Act. So on the construction principles, we first have to ask ourselves, and there are lots of issues that arose on construction in this case, but we first have to ask ourselves, what evidence is admissible when construing the terms of a trust like this? And we had discussion earlier about the case of Marley and Rawlings, and that was brought up again in this case. But Chief Master Sherwin was very keen to distinguish between objective facts, which are susceptible of proof, and direct evidence of the subjective intention of the settlor. because in this case we had a number of additional documents to the trust. There were some memorandums of there was a memorandum or letter of wishes, and there was also some biographical information about the settlor which was of relevance, and that biographical information was a biography which clarified that the settlor of this trust was a gay man. Now, Chief Master Schumann accepted the admission of this biographical information on the grounds that it was an objective fact which was capable of proof. And that is something that we may come back to later as one of the takeaways from this case, because that is the boundary between subjective intent and objective facts which are capable of proof is a fairly grey one, to say the least. So that's what evidence is admissible. Then we have an important element of this, which is the nature of the trust itself. This is an employee, or essentially an employee benefit trust. So it's not a family trust with a small number of beneficiaries. This is an employee trust with a very, very large number of potential beneficiaries. And in that context, the Chief Master determined that it should be interpreted, or the clauses of it should be construed in accordance with the commercial purpose of the trust. And so taking those first two elements together, Chief Master Schumann determined that on commercial principles and taking into account the commercial context of this trust, it cannot be right to construe the word spouse to exclude a wider definition of couples who are recognised in law. So for that reason, for construction reasons, both civil partnerships and same-sex marriages were deemed to be included in the word spouse in the trust deed. But the other aspect was the Human Rights Act element. Now, we've already seen the specific provisions of the various acts, and we've already had some discussion of the two statutes which create same-sex marriages on the one hand and civil partnerships on the other. And to sort of give the game away to start with, Chief Master Schumann found that you could use the Human Rights Act to incorporate same-sex marriages into the definition of spouse, but you could not do that to incorporate same-sex civil partnerships into the definition of spouse. Now, let's start with the civil partnerships issue, because that is the real distinction here. Why did that not get the same treatment as marriages? Well, the reason that Chief Master Schumann gave is because she determined that one of the fundamental intentions of Parliament when creating civil partnerships in the 2004 Act was to create a separate route to the same benefits of marriage, but which crucially was not marriage. And she determined that that was a fundamental feature of that Act. And led by a House of Lords authority, Gaidan and Godin Mendoza, which similarly dealt with the rights of civil partners, she determined that where the court was being invited to use the Human Rights Act to read down an essential feature of a piece of legislation, the court shouldn't do that because that blurs the line between interpretation and amendment. And so on that basis, she decided that to read down the Civil Partnerships Act 2004 would be to go too far. And so despite agreeing that its result was somewhat discriminatory, she declined to include civil partnerships within the definition of spouse in this trust deed through the Human Rights Act route. Now, that was not the same for the Marriage Same-Sex Couples Act 2013. And the reason for that, as a starter, is that it did openly extend the benefit of marriage itself to same-sex couples as well as opposite-sex couples. And what the Chief Master decided was that the part of Schedule 4, I think it was, which essentially preserved the discriminatory effect looking backwards, was not such a fundamental feature of this Act. The fundamental feature was to extend the rights of marriage to same-sex couples. And so the Chief Master felt that she could read down that section in a way that would make it non-discriminatory, and she could therefore include same-sex marriages within the definition of spouse for reasons of the Human Rights Act as well. So the Chief Master arrived on the spouses issue at the same conclusion for both of them on traditional construction principles and did follow the authority of Rehand only on same-sex marriages, but not on same-sex civil partnerships, which will be of interest in a moment. And finally, just on the issue of children, the argument was again raised that the Human Rights Act could be used to read down the word children, but the Chief Master refused to do that in fairly short shrift. And she said that that's because sometimes law distinguishes between categories, but that does not necessarily mean that that law is discriminatory. So that was the decision that the Chief Master alighted upon. And from that decision, from this judgment, there is a lot that actually could be taken away. So here are some takeaways and some discussion points that we're now going to talk about.
I'm doing the first one. Okay, so what's actually interesting about this case?
You have to go to the microphone.
Oh, sorry.
The voice at the back will get very cross.
Sorry. Normally my voice is loud enough for this, but anyway. So what's interesting about this case is that it moves on from Rehans, Redruces, and various other cases, because those prior cases were all concerned with looking at legislation, the Adoption Acts and the like, and using the Human Rights Act, and in particular Section 3 of the Act, to read down the express provisions of the Act which were discriminatory. What was different about our case is that the discrimination was actually in the common law, and in particular in the common law definition of spouse and in the common law definition of children. And so the takeaway is you can attack default common law definitions as much as you can statutory provisions, in particular by relying on Section 6 of the Human Rights Act, which is the court's duty to interpret and to behave consistently with convention rights. In essence, the judge accepted my submission that if the common law was discriminatory, Section 6 forces the court to make it not discriminatory. So that's the first takeaway.
The second takeaway is an issue of retrospectivity. This was raised in Hand, and it was raised in the present case as well, which is this question of if the instrument was drafted in 1990, and in Hand the instrument was drafted several decades before that, how can it be appropriate to use a 1998 item of legislation to alter that instrument or to construe that instrument? And what are the limits on the court's approach there? And in both situations, the position that the court alighted upon was to determine that when establishing and ascertaining who the beneficiaries are, that is in itself a new act. And that act takes place, of course, after the 1998 Act. So what you get is a post-act event, and that act and the court's role in participating in that act, or the court's role in ascertaining those beneficiaries, must itself be convention compliant under Sections 3 and 6. So that's the limit of the court's approach on retrospectivity. There is a further question, though, which arose, and in this case, as I've said, we are dealing with a large employee benefit trust in a commercial context with a potentially very significant number of beneficiaries. Chief Master Schumann does talk about there being a difference between that and a small family trust setting. Furthermore, there are differences when you have accrued rights and rights that have already been accrued, and the court is being invited to alter those accrued rights. Now, that did happen in the case of Hand, and Mrs. Justice Rose there said that she thought that it would be fair to alter those accrued rights in line with the Human Rights Act. But there has not been a significant discussion of this so far, and this is something of a live issue on how accrued rights are affected and what would happen in the case of a smaller family trust as opposed to a larger commercial employee benefit trust. So the questions of retrospectivity and the questions of what would happen in the circumstances of each particular type of trust are still ones that have grey areas around the borders.
Yeah, and just to pick up on what Harry was just saying, of course, it's not just a difference between family trust on the one hand and more commercial trusts on the other. It's really a difference between fixed interest trusts or trusts where the interests are very tightly defined and massively discretionary trusts. So it's obviously very uncommon in your standard, very widely discretionary trust that anyone at any particular time has an accrued absolute interest in anything. And if you've got that kind of trust, then these arguments, I think, are still much more open to you because you're not interfering with anyone's accrued rights. Indeed, the whole tax purpose of the arrangements in the first place are normally that no one has any particular accrued right. The third takeaway is don't forget in this context that it's not just the Human Rights Act and all that fancy learning that can help a more modern approach to trust interpretation. The primary basis on which we succeeded on both issues in relation to spouse was actually ordinary conventional interpretation provisions, looking at the relevant background or the factual matrix in the jargon and interpreting the words in that light. And Harry's already explained the important elements at work there. My submissions are obviously always a bit blunt and dull, but my submission about the settler and what the relevant background can include was slightly more nuanced, perhaps, than is recorded in the judgment. It wasn't just a definition. It wasn't just me saying, well, because the settler was gay, therefore you must interpret this in a way that is friendly to the rights that gay people have acquired. There was much more in the biography about the settler's beliefs and values and wishes. For example, that he was somebody who was committed to the struggle for equality and stuff like that. Although, as Harry has cautioned, and as the judge cautions in the judgment, it's a pretty thin line between, on the one hand, saying you can introduce objectively evidenced facts about the beliefs and personal characteristics of the settler, and on the other hand, saying what you cannot do is take into account the subjective intentions of the settler. And it might be said, perhaps, that in walking that line, I was on slightly thin ice. But that's quite an interesting, arguably developmental part of the judgment, which will be interesting to see how it plays out in the future. That's the third takeaway.
And the fourth and final takeaway really follows on from that point about subjective beliefs and the individual beliefs of the individual. Because what the Chief Master didn't really seem to grapple with in her decision was this point that was raised in the Steinfeld case from the Supreme Court, which is that a major reason that people enter into civil partnerships as opposed to traditional marriages is a philosophical belief in the badness, I suppose, of the institution of marriage. And so what was not dealt with was the possibility of discrimination, not necessarily on the grounds of, what one might consider to be traditional discrimination in equality law, but rather the right that is preserved by the Convention, which is not to be discriminated against on the grounds of protected beliefs. And the bar for that is very high. And in my view, certainly, the political belief or the philosophical belief in not getting married qua marriage would be one of those protected beliefs. So a potential avenue for this to continue to be argued into the future and potentially at a higher level before a sort of more senior judge would be on the grounds that not to include civil partnerships in the common law definition of spouse is to discriminate actually on the grounds of discrimination on a protected belief. That's something that the Chief Master didn't deal with in her judgment, so it's still a live question. That was obviously not specifically the context of the construction argument here, which was about predominantly same-sex couples. But that is something that it will be very interesting to see developments on in the future. And I suppose a broader inclusion of different rights protected by the Convention being included in definitions in trust deeds using those Human Rights Act principles. So that's the fourth takeaway, and I think our last takeaway, unless you have anything else to add.
No, just on the last point there, it wasn't actually restricted to same-sex couples. I did argue precisely the point that Harry has put much more elegantly than I did in the case itself, which the Chief Master sort of skates over by saying, well, it would do violence to the Civil Partnerships Act 2004. The real argument, and the argument that will be made in the future, I'm sure, was rather that the problem is the common law definition of spouse. It's got nothing to do with the legislation, actually. The argument is that the common law definition of spouse, if restricted only to people who are married, is, I would suggest, obviously discriminatory on the basis that Harry has outlined. for precisely the reasons that the Supreme Court give in the Steinfeld and Keating case. Civil partnerships and marriage are, as the Supreme Court held in that case, just two different gateways, I think is the word they use, to the same set of spousal rights, I think was the lingo that they used. And if that's right, then I do struggle to see how it isn't discriminatory, how the common law isn't discriminatory in perpetuating the traditional definition of spouse. But that'll have to wait for another case soon, I hope.
So now Owen Curry is going to take the stage for us. Well, there's little that Owen doesn't know. And it took all my powers of persuasion to persuade him not to deliver his presentation in Latin,
Let's save that for the Donati Mortis Causa one.
or to sing it in ancient ecclesiastical chant. Today, he is our very own James Bond, because he is going to delve into the world of secrecy.
So, what am I trying to achieve here? Well, I want to try to give you a quick introduction to the broad subject matter of secret trusts, and then try and extract from two recent cases. Unfortunately, we didn't have a member of Chambers involved in both of them, although the judge was a former member of Chambers, so that perhaps counts. Two recent cases, Titcombe and Isom and Re Mattingly, which are both secret trust cases in 2021, to try to take out of them some practical advice about how to approach these things at trial and when considering the merits. Because if you pull down Theobald on wills or Lewin on trusts and read about secret trusts, you fairly rapidly descend into references to the importance of the Statute of Mortmain of 1736, which I'm very happy to talk to people about later, if anyone is interested. It is actually quite an interesting subject. And a welter of very technical distinctions. But, I mean, in practice, a lot of those issues are really quite unlikely to come up. And some rather more common or garden, rather more at the Daily Mail end of the spectrum, to pick up something Elspeth was talking about earlier, considerations of evidence will be, I suggest, more important. So what is a secret trust? What is it all about? It is when a testator, or in his or her will, or actually through his or her intestacy, gives a gift to a primary donee that, on the face of the will, appears to be an absolute gift to the primary donee, or at the very least does not set out any further trusts on which the gift might be held, when in fact the primary donee has agreed to hold that gift on trust for one or more secret secondary donees on terms agreed with the testator. What do you have to show then to prove the existence of such a trust? You have to show intention to create a trust, communication of the terms of the trust, and acceptance of the trust during the lifetime of the testator. And that acceptance, and I'm already failing to resist the temptation to start descending into technicalities here, that acceptance can, for example, be communicated through agents on the appropriate facts. Now, the traditional distinction drawn in the field of secret trusts is between half-secret trusts and fully secret trusts. And what is that? Well, a fully secret trust has a primary donee that looks like an out-and-out beneficiary on the face of the will. And a half-secret trust has a gift on the face of the will to trustees, although the terms of the trust are not set out. Now, I'm sort of going to try to move beyond that distinction for the rest of this talk, but just so you have a reasonably full picture here, why might that distinction be important? Well, it is important because there are different rules, in particular about the communication of the trust to the primary donee, depending upon whether the trust is half-secret or fully secret. In particular, in the case of a half-secret trust, the communication of the terms of the trust must be no later than the date of the will. And now, I think the point to draw out from this is that you can easily get caught out with a half-secret trust if you mess up the communication. What I want to suggest, however, is that a practical way of thinking about secret trusts these days is not so much to ask, is this a half-secret trust, is this a fully secret trust, but instead to ask, is this a trust that whoever is involved in creating it has attempted to create with a certain degree of formality and deliberate intention or not? Because if it is one of the former type of cases, the sort of formal secret trust cases, you are likely to have to deal with a different set of issues than in an informal secret trust case. So what do I mean by that? Well, plainly, a half-secret trust must have a certain degree of formality about it, because someone has taken the trouble to say that there is a trust on the face of the will. But you can have a fairly formally created secret trust. There's no particular reason why the secret trustee and the testator should not have recorded in some reasonably comprehensive memorandum what the terms of the secret trust are. And indeed, in the case of a fully secret trust, those terms could potentially be varied at any point prior to death. Now, in a world of discretionary trusts and powers to add and remove beneficiaries and letters of wishes, one may wonder whether there's any real space in practice for this sort of arrangement, and to be honest, maybe there isn't. But it does happen, and the most recent example of that is the estate of the painter Lucian Freud. There was a claim in 2014 by the beneficiaries of £42 million worth of assets under his will. What they were trying to do in the litigation was prevent one of his other children find anything out about what had happened to his estate. And the way they did that was by bringing a claim for a declaration that they were absolutely entitled to the assets that they received on the face of the will, even though it was their positive case that they held those assets as secret trustees. So that is a case of a formally created secret trust. And in such a case, the issues are likely to be, well, is it a fully secret trust? Is it a half-secret trust? If it is in fact a half-secret trust, has the communication taken place at the right time? Has it taken place in accordance with the strict terms of the will? Is the half-secret trust valid? Really, the other category of cases are the informally created secret trusts. And it is that I want to spend the rest of my time talking about. If you look in the books, you can find quite a few of these cases. There's Ottaway and Norman from the 1960s, Rees Snowdon, Casper, Bauer and Griffiths, which I would recommend as a good Court of Appeal case that sets out all the requirements very clearly. And two recent cases, Ree Mattingly and Titcombe and Isom. Now, what is likely to be significant in an informal secret trust case is whether there was a provable intention to create a trust. Clearly, the person alleging that there is a trust is starting at a bit of a disadvantage given the informality of the situation. And what I suggest is, in most circumstances, even in potentially very promising circumstances, it may well be difficult to persuade a judge that the testator really intended to impose fiduciary obligations on someone who appears to take a free gift under their will. So, Mr. Ison had met a lady on a cruise, so we get into the Daily Mail, and that lady, she was the survivor and I think both the other parties were still alive when Mr. Ison first met her. She was the survivor of a 50-year ménage à trois. She had inherited quite a lot of money as a result of that, and after she met Mr. Ison, they got on very well. They went on lots of other cruises together. He looked after her jewellery, and then she died, and she left him everything, slightly to the annoyance of her brother's family and her niece in particular, and a claim was brought that the jewellery was held on a secret trust. Now, in Mattingly, a slightly more mundane situation, there was a mother had left an interest in property she'd left it to her sister, but subject to an understanding that the sister would look after her 16-year-old daughter. And the daughter subsequently brought a claim that the house was held on trust. Now, both those claims failed. Why was that? What were the important bits of the evidence? And I wish to give you a reasonably short list of factors to consider. First, and it's a very natural starting point, well, what written evidence is there, if anything? And along with written evidence, what other undisputed evidence is there that might point to a trust? In Mattingly, there was a mishmash of documents, none of which were really consistent with there being a trust, but they didn't rule it out. The claimant in Ison probably felt that they were on rather more promising ground because Mr. Ison subsequently got divorced, and in the course of his divorce proceedings, he said to the family division that he was a custodian of the jewellery that he had inherited. Now, one might think that that was a fairly promising basis on which to advance a claim. But you have to be careful about what look like very helpful things like that, which when placed in their proper context may not in fact turn out to be quite as helpful. So, second, was there any reason for secrecy? The judges in both of these cases commented that there was no particular reason or need for a secret trust. Unlike Lucian Freud, these people didn't have a large and mysterious class of children for which they wished to provide for secretly. It would have been very easy, as both judges commented, for them simply to leave the alleged gift in their will. And both of them had lawyers who could easily have helped them do that if they had wanted to. The natural inference, therefore, was they were quite happy with making the outright gift that their will appeared to make. Another thing to bear in mind, and a feature of both of these cases, was has there been any delay, or is there some sort of broader context? The judge in Mattingly, for example, commented that the claim that there was a secret trust arose out of an increasingly bitter dispute between the aunt, that is the sister who'd got the property, the daughter, and the ex-husband of the deceased. And that the credibility of the evidence that there had been this secret trust arrangement was called into question by the long delay before the claim was formulated. A very similar point was made in Titcombe and Isom, where the deputy master also observed that you could see on looking at the documentation that what what the claimant had really been worried about was not so much the jewellery, but the fact that Mr. Ison had inherited the rest of the £5 million as well. And it simply seemed to be the case that once she'd found out about the family division proceedings, that looked like the lowest hanging fruit. And finally, and this is really I think I've got through 4 things now. The final thing, and really the most important thing, and this goes back to an Irish case, although it was subsequently upheld by the House of Lords, called McCormack and Grogan from 1863, I think. Did the testator really intend to create a trust? What is it? Is it? And that question should be phrased or repackaged by saying, did the testator really intend that what they were doing should be enforceable by an action in the Chancery Division, as we seem to be saying these days? I suppose we should probably say the Business and Property Courts, but there we go. And I suppose what I want to leave you with is that in most cases of informal arrangements, Otway and Norman is an exception, that is really a test that is very unlikely to be met. Very few people, when having informal discussions about what they might want people to do with their assets after their death, and assuredly people do have those discussions very frequently, actually intend that the friend to whom they're leaving their assets or the child to whom they're leaving their assets should be open to being sued as a result. So I suppose, to sum all this up, if you are looking at not a formally created secret trust, but some sort of more informal secret trust, much like if you are advising on a fraudulent calumny or an undue influence claim to challenge a will, the right answer is probably try to persuade your clients not to bring it. I'll leave you with that.
So Heather Murphy is going to bring up the rear of our afternoon, but that's in keeping with the practice of simply saving the best till last. She's going to educate us about what to do when you can't find your beneficiaries.
I'm going to talk about Womble Bond Dickinson Trust Corporation and Persons Unnamed, one of the more snappily entitled cases that we've talked about today, and in particular 3 questions that arise from it. When will the court appoint an advocate to the court, which is a tongue twister? What is said advocate to the court's role? And when you don't have obvious beneficiaries such that you need to have recourse to an advocate to the court, how on earth are the trustees meant to administer this horror show? So this was a case which had not only 1, but actually 2 members of chambers in it, because I appeared against Adam. And you might think quite obviously, if Adam was for the trustee and there's no defendant, for whom did I appear? And the answer is I didn't appear for anyone. I had no client. The underlying issue, if you like, which took this to court was that the trustees had taken on what could only fairly be described as an administrative horror show, because it was a very informal sort of employee benefit style trust created in 1986. It was designed really for the provision of sports provisions for various people employed by PD Group. It spiritually replaced a 1920s similar sports provision trust that had also been for the benefit of all of these employees, but really only the ones who could reach the Hampstead tennis courts. So the trustees were fixed with a problem of what was their beneficial class. It was designed to be the beneficiaries of those who were employed by PD groups. And there were 2 rival interpretations. First, did the trustees sit down and think, right, who falls within, what companies fall within PD groups at the moment, and who are the current or former employees of that group? So looking very much group level down. Or alternatively, looking at any particular individual, were they employed by a PD group company since 1986, even if they were no longer employed by that company, or that company was no longer a group member, it moved out of the group. And these 2 interpretations had 2 very different outcomes, because if the first, the look down, established what your group is and then look to see who falls, who's an employee of that, By the time we got to 2020, PD Group had ceased to exist. So you would simply look at this and draw a circle that said nothing, there's no group, so there's no employees, and therefore would all go to charity. Whereas the second interpretation, you would instead have a whole host of beneficiaries who'd been employed since 1986 by various companies, all of which had now ceased by 2020 to be members of PD Group, but which were, at the relevant time of employment, group companies, and therefore the employees were beneficiaries. Now, this caused two real problems. First, who do you appoint as the defendant to ascertain or deal with this construction point? Because there's no one who falls within both categories. It's either charity, and an unnamed charity, or a massive group of employees. And the second problem was that the trustee was relatively late in the course of this trust to this party. It had no contemporaneous knowledge of who had been employed since 1986. So finding and appointing representative beneficiaries was, frankly, impossible. And so they were dealing with a very large, unascertainable class. So the trustees, very sensibly, if I can say so to Adam without being patronising, commenced Part 8 proceedings without naming a defendant and got permission to do so. And the court granted permission on the basis that the former trustees, from whom Womble Bond had taken over, were invited to defend the litigation, or, if they decided that they were well out of it and they didn't want to participate, that an independent counsel was appointed. And unsurprisingly, the former trustees thought, nah, we're fine, and I was appointed. So, this then comes to the first question of when will the court appoint an advocate to the court, and really under what power was it doing so? Because if you look at the fabulously interesting Practice Direction 3G, which is tip-top reading for insomnia, you will see that really it was designed, as well as modernising the idea of advocate to the court, to really restrict its role to people appointed by the Attorney General or the official receiver or the like. And so you have this request being made and then someone being appointed. Now, that was not what happened here. And I think, although I have seen some question and comment about whether or not the court went a bit off the rails on this, I don't actually think that's a legitimate concern, because to begin with, the practice direction simply supplements CPR 3.1, which, as we all know, is an incredibly wide power for the court basically to case manage in any way that it likes. Secondly, the practice direction is simply in most cases, and this seemed to be therefore very much a case which didn't need an Attorney General reference. And that's because really what was happening here was the court was trying to find someone to replace a representative beneficiary. The trust fund was going to be paying the cost, and it's really very difficult to see what the Attorney General or the official solicitor would have had to do or added to the party that couldn't have been achieved by the solicitors to the trustee simply finding independent counsel and appointing them. And so I think, although Practice Direction 3G indicates it should be, or in most cases, should be an Attorney General reference, I think this is quite a useful point to say that actually in trust cases, if you are stuck without representative beneficiaries, this might be a nice route that allows you to get the arguments before the court without having to embroil the Attorney General. So in that case, what are the sort of considerations that the court might give to appointing an advocate to the court? Very simply, whether you're looking at Practice Direction 3 or the historic case law, it is simply to assist the court in hearing the relevant arguments. There was provision, happily, in the order setting out what the scope of my role was, which was to argue the contrary points to the points that the trustee had, and beautifully drafted to argue any other legal argument that I considered fit. What an advocate to the court ought not to be doing is advancing facts or evidence or investigating or challenging those facts or evidence. And I should say at this point, if you're in a situation where you're thinking representative beneficiary or can we try this advocate of the court route, and you think, but there will need to be some evidence, that is quite a good pointer to the fact that actually this is a representative beneficiary issue. But happily here, as this was a pure question of construction, there was no evidence to be advanced by me. What is the advocate's role? Second question. Well, very simply, to assist the court to hear the relevant arguments. That doesn't really assist in trying to work out what necessarily the advocate ought to be doing in preparation for the hearing. And there isn't actually a great deal of guidance beyond a very broad, vague, you should assist the court to put forward the relevant arguments. It all gets rather circular. It is, in my experience, a rather similar exercise to when you're acting for minors and unborns. You don't have any clients with whom you can liaise, although I have on one occasion been threatened that I might have to babysit my clients, which I fortunately avoided. But it's about assessing, if you like, given that there's this amorphous and may never exist class of people who cannot put forward the arguments, what are the points that you may like to put forward on their behalf? And I think this was made easier because the trustees had identified at least who the potential beneficiaries broadly could be. I was acting, or the arguments I was advancing were the ones that would favour the people who had been employed by the PD group. So if you like, you could encapsulate, in a very vague sense, who these might be. So if that's the when do you get an advocate and what's their role, what about the more probably common question of how do you administer a trust when not all the beneficiaries can be identified? So as I said, the court found, after some argument and then coming back to us to have another chat and then judgment, that the beneficial class was anyone who'd been employed by the group since '86, provided that the time at which they'd been employed, their employer was a group company. And that included those who had left group companies because they'd retired or had gone for other jobs, or whose employer had left the group. And to make the class even wider, it included their spouses and dependents. Now, as I said, the trustee really had almost no information about who was within this class. And although the fund was £900,000, it was in the context of employment of over 30 years, a relatively modest sum. So the trustee decided to surrender its discretion to the court and put forward 5 alternative routes forward as to how administration can occur, which I won't read out because they're on the screen, with the idea of how best could it give practical effect to the trust. Now, the court, having found that there were, if you like, human beneficiaries, rejected argument 4 that the trustee should still apply the fund to charity, if nothing else because there was no guarantee that a natural beneficiary would benefit from that action. And it also said that advertisement under Section 27 of the Trustee Act wouldn't actually work in this situation to solve the trustee's problems. And so the court settled, although it said that 1 to 3 were variations on the theme, it really settled on option number 2, which was to direct the trustees to distribute to known beneficiaries only. Now, the trustee was pretty frank with the fact that it had a limited list. It had tried to ascertain who beneficiaries were. It had written dutifully to many companies, some of whom had been helpful, some of whom were liquidators and were therefore not fantastically helpful. And it had come up with a list. It wasn't a perfect list, but it had some names. And the court considered that although advertisement was an option, it could lead to spurious claims, and although current knowledge was arbitrary because it was simply dependent on whether or not the person at HR had responded or the liquidator was in some way motivated to act, that actually directing the trustees to distribute to known beneficiaries on an equal basis was going to be the fairest route forward. And so in terms of considerations that it had as to the method of distribution and also rejected, it considered whether or not it ought to be on a basis of hardship, because then you could do greater good with the money, but thought that this was going to be too expensive. And it also excluded spouses and dependents, in part I think because it didn't want to grapple with the question of whether same-sex spouses would be included or civil partners. Now, the court, having excluded them from benefiting, did do a little footnote to suggest that it thought in this trust same-sex spouses would be included, but civil partners were more of a query. But fortunately, the trustee wasn't going to have to grapple with that because it was purely former employees. And so what the court came to was an incredibly pragmatic decision that although some of these employees, sort of dock workers, there was some indication that there had been, for instance, industrial disease, and therefore there might be a great deal of need, that it was going to go for equal division as simply the fairest and most pragmatic route, and that the beneficiary, the trustees, didn't have to undertake any wider searching, because to do so would continue to deplete the trust fund. So the trustee was directed to spend some money in tracing and ascertaining the beneficiaries it had, and any other beneficiaries who made themselves known in the process, because we suspected that as word got out, if you like, that so-and-so had received a letter because they'd been employed at PD Docks in Sunderland in 1990, they might tell their friends who might write to the trustees. And so how does the trustee left to administer the trust? Well, at a consequentials hearing where the court approved, if you like, the full scheme of distribution, which included the timetable, the methods for tracing, and the various correspondence. And that, if you like, allowed the trustee to find at least some route forward for the people that it knew to benefit in a way that was cost effective to the size of the trust fund and proportionate in relation to at least those beneficiaries of whom it knew. What, therefore, if you like, can we say are the lessons that this case might assist you? Well, I think it's actually quite a reassuring decision for those who are advising professional trustees. The court wasn't at all bothered by the idea that the trustees were surrendering their discretion. They thought it was a fair case in which to do so, that trustees shouldn't be discouraged from taking on difficult trusts, and this clearly fell within the difficult trust. It came to a pragmatic, if perhaps outside the scope of Practice Direction 3G approach to representative beneficiaries, or an advocate of the court. And it came to a pragmatic approach as to how to ascertain beneficiaries when one simply had a large class with perhaps masses of different need, but a great deal of difficulty and cost in ascertaining them. And so, although I started with the case of the missing defendants, I have to say this is a case where the defendants missing is not so mysterious, and in fact the court has been deeply pragmatic and practical.
To presentations on private client issues and court of protection issues. We have run seamlessly through Edward and Tim's thoughts on capacity, what to do in the penumbra of doubtful capacity, and the ramifications of the open your pockets approach of the Court of Protection. Through Helen addressing the knots into which the recent decisions on the question of whether making a gift to surviving children excludes a stirpital succession of a predeceasing child, and the knots that the cases appear to have got themselves into in that respect. Bajul then took us through the recognition of heresy, namely an oral will made by someone other than a member of the armed forces. Sarah introduced the good, the bad, and the ugly in terms of conduct in Inheritance Act claims, before Adam and Harry addressed identifying beneficiaries by reference to the Human Rights Act and reading down a will or a trust deed, which I think is simply code for change or alter the will or trust deed by applying retrospectively legislation to a private disposition of wealth. I make no further comment on that than that. And then we had Freudian secrecy over a £42 million disposition by will. Finishing just now with Heather dealing with the unknown and a bit of pragmatism in appearing for invisible clients. What a whirlwind. What a tremendous effort on the part of the members of 24 Old Buildings, which I hope you've very much enjoyed as I have. I think we've all earned now a glass of punchy or something stronger, if you can get stronger than punchy. So please do join us for that. Please do ask any questions, but I suggest we do that over a glass or two outside that you have of any of us.